Hello, everyone. This is Dr. Jackalyn, Rainosek with DTP-Leadership Group. But this is Hot Topic Bold Talk. And I'm so delighted to have my lawyer friend, Richard, with me today because he's the one that has all the knowledge and expertise. But I certainly have some of my own experiences with things that we're going to talk about today. Now, this is podcast 147. And we're really going to be talking about the Calais court case that's going to have some major impacts, but then we're going to talk about judges and aging. So, Richard, I'm delighted to have you here. It's so good to see you, and thank you for doing this so much for me and
And
for the rest of my listeners.
thank you for having me again.
Thank you. Well, I look forward to it every month because I think people are benefiting. So I have a number of questions for you, and because I want to see if we can't cover all the wonderful things that you've given me. And listeners, I want to let you know I have three excellent articles he gave me. So a lot of the questions come from those articles, but you will have them available to you as always. You know I give you your references. So my first question is with Louisiana versus Calais. How would you describe, Richard, the decades of legal precedent in the Civil Rights Act of 1965 that protected minority votes? Because it
Well,
really
that
concerns me.
yeah, that and when that is something we discussed in kind of much greater detail last month. But obviously the key issue, and ultimately, since we're talking about Calais, we're talking about Section 2 of the Voting Rights Act, is the issue of protection along the lines of race and the preservation of one's, different societal groups, in particular, a race's ability to have equal representation in the government. Um, I believe that what has happened in the past, 50 plus years since the Voting Rights Act was passed has gone a great deal towards correcting, but has not completely changed certain, for lack of a better way to put it, biases that have existed for a long period of time and still exist. If if you want to call it prejudice. But um, you know, there have been steps that have been taken. There are things that have been accomplished. In particular with Louisiana. Uh, you know, for right now, at least, with the election of Cleo Fields in that newly drawn district that has been challenged, you have two African Americans representing the state of Louisiana in the House of Representatives of Washington, D.C. And I don't think I'm the only person that believes that without the Voting Rights Act, that number would be one or zero, depending upon
Right.
how um, the the people that decide those congressional districts might choose to crack, in particular, Orleans Parish, which is a concentrated area of minority votes in the state of Louisiana.
Well, and the thing, I think you're making excellent points. And my concern is, I was in college during the Civil Rights Act and its passage. And what I'm seeing is we're going backward in this country, and minority voting is a way that people that are taking these state districts and gerrymandering them to allow more Republican representation is very much denying the aspect of race. And I think minorities based on race is extremely important. I'm looking at the gerrymandering that's been done in Texas, or the one in North Carolina, or the one in Missouri. They're all dreadful ways to make a white domination in representation rather than a representation of the voters in a state. So I don't know what you want to say about that, but that's where I am with it. My concern for Section 2, the Civil Rights Act, not being weakened by the
Well,
Supreme Court.
yeah, and ultimately, for the time being, because there has been no decision on Calais, it was just re-argued, not 2 weeks ago. What we're facing right now is a circumstance where um, the Voting Rights Act, as you and I discussed last month, is still in effect. Now, if you remember at the end of our conversation last month, um, I presumptively told you that I thought that the court would stack a certain way in one direction and the other, and that, in my opinion, ultimately how the whether Section 2 stands, and if so, what is left of it is going to depend upon Justices John Roberts and Brett Kavanaugh. And I must say that since it was argued, and in hindsight, with the oral arguments having taken place, apparently a lot of people that get paid a lot of money for doing this have um, come down the same way as I did with my not quite wild ass guess for you last month. In
Wasn't a
particular, a
wild
lot,
ad guess. Yeah.
but in particular, a lot of people are thinking that it's going to come down to what Brett Kavanaugh decides to do. That questions that were asked by certain of the justices, in particular, John Roberts, seemed to suggest to some people that try and read the tea leaves that he might be looking of some way that race would continue as a factor, but could no longer be a predominant factor in drawing up legislative districts. Whereas one of the particular questions Kavanaugh asked that people seem to be hung up on is whether or not there should be an expiration date on statutes like this that were passed to attempt to rectify the wrongs of our historical past. And in regards to that question, I would say that the the point made by the person arguing in favor of the Voting Rights Act, I think, was appropriate and is very important. And what she mentioned to the court was, since Reconstruction ended post Civil War, Louisiana still has not yet elected an African American to a statewide office.
Amen.
So, to the extent you want to look at an expiration date, I think that would be a good example for why, uh, you know, if the Voting Rights Act has a sell by date, we're not there yet.
Well, and I don't think we are at all, because I've spent 50 years of my life trying to work with people, appreciating difference, looking at culture, looking at all kinds of categories to be certain that we accept and learn about people so that we can understand things. I think we're going in a direction where I haven't seen in years. Pre, it was pre-civil rights that I'm seeing the things that are going on now. One of the things that disturbed me that I haven't put in some of our notes for each other, but it's disturbing to me that we're going to open up immigration to 7,000 more South Africans, whites, but we're not going to open up to other things. And I think what we're seeing is I'm reading articles where the N word is beginning to be used. There are lots of things that are very demeaning to various races that are now coming out. So for me, I'm hoping Kavanaugh, somewhere in his heart of hearts, realizes that we have not advanced to the stage where we truly have a socially just rural, country that we live in that treats people, no matter what their race is, that they are treated with respect. So that's my concern. One of the things you mentioned, was just briefly about the argument to justify to justify keeping the Section 2 in, and keeping it there. Can you give me any more about how there is a support for doing that? Because I liked your comment, but I'd like some more if you have it.
Um, to me, in large part, because again, ultimately, I don't think Section 2 will be completely done away with. Because if it's completely done away with, you could see the return of things like poll taxes or voter registration tests, some of the really asinine things that were done to
Right.
keep segments of the population from voting. And I think even the most conservative jurists on the US Supreme Court realize that that's a bridge too far. I think that the direction we're going, if a change is made, like I said, is going to be something where race can no longer be a predominant factor. And again, these terms are arbitrary. Quite often, it's
Right.
the old Potter Stewart line on pornography. It's been oft criticized. I know it when I see it. You know, the but it can't be a predominant factor that perhaps Roberts is going to try to massage it so that race can or should be considered, but can't be a predominant factor. And what I mean by that, and presumably what the court means, is when we look at the Alabama case, Shelby, when we look at Callais, there was this decision that, okay, because 2/3 of the state population is African American, 2/3 of the districts need to be African American. And that is making race a predominant factor. The concern is if you don't look at it in that regard, then how much wiggle room is being given? And that was, you asked about this, the comment made by, I think it was Justice Sotomayor, is, well, whether you strike it down or you lessen the consideration given to race, this it's of the same effect. Section 2 of the Voting Rights Act goes away. And I think this ties to, and again, I'm not going to disappear down the rabbit hole with you on this one again. I'm simply going to touch on it briefly, is the ability to draw the districts. If race can no longer be the predominant factor, but is a factor, the concern is in states like Louisiana, maybe you have one district, maybe Orleans Parish is African American and that's it. In states like Texas, you'll have a handful of districts, maybe, urban Dallas, urban Houston, perhaps East Austin, certain areas where you've got a tight geographic concentration of a minority group. But the end result is, in a state like Texas, where you have over 30 congressional seats, you're talking about three, four, five, and that's, I think that's the concern. And you asked about the particular indicators. I would go back to what Sotomayor said, Justice Sotomayor said, which is that, look, if you start taking any of the air out of the balloon on this, if you make it any weaker, you're essentially doing away with it. You're giving, you would be giving the people that draw the congressional districts an excuse uh, to do it differently and to really minimize, if not eliminate, the consideration of race in drawing these districts.
Yeah, and I think that's one of my concerns is that I see Texas already having gerrymandered. I'm seeing the other states and how they've gerrymandered it. And we mentioned all those kinds of things. It would take a number of Latinos in certain, in these various districts to even overcome this. Now, I'm hoping that there are some Republicans that are not megas that would say, I don't like this redistricting and I don't support gerrymandering. I don't know what's going to happen. But I think you've
And
covered it.
again, I apologize for interrupting, but it cuts both
No,
ways. I
no.
mean, if you do away with this, what's to keep, say, a state from Illinois, which is heavily Democratic, from suddenly taking, farming counties in southern Illinois and drawing them into a long district that takes in the south side of Chicago, or in California taking large portions of the rural agrarian Central Valley that are, 70, 75% Anglo, and tying those into districts that have a heavy Latino population, or, the thing is, and it's getting more this way every day because, despite, the growth of this country is coming in what used to be referred to as minority populations. I mean, the reality is, I don't know that we have any one segment of the population that now makes up over 50%. Maybe I'm wrong. I'm a
No,
lawyer, not a
no, you're
sociologist.
correct. You're correct because I've looked at it. Yeah. And what I think is that we're talking about is what are the implications for our country if they do something to weaken Section 2. And I think we've covered what it is. And you know, when I see people trying to take away the right for people to vote and have representation in Congress, then I cannot support that. My highest order of value that I have is social justice, and I do not think I see that as a socially just process. So I'm going to be very interested in Calais, and I truly am hoping that if Roberts can convince Kavanaugh and they can come to some reasonable way, then I won't be as disturbed. But if I'm hoping Roberts and Kavanaugh can come to something that makes it reasonable and that we can still have one of the most important sections, I think, of the Civil Rights Act. So if you want to say anything more about this, that's great. But I know we've got a bunch of other topics that we're going to cover.
No, I think that about covers it, and perhaps this is a good opportunity to move on to something that I've touched upon previously, in particular with the lifetime appointment of United States Supreme Court justices, and talk a little bit about judicial selection, if that works okay.
Yeah, and I think it's very important. And the articles you gave me were fascinating. I had no idea that we had judges that are in their 90s and we have the one that's 100. Now, I think there are lots of things that you can provide us. So I'm going to go through and ask you some more questions because I think it'll help direct our conversation. So my first one is there's an interesting story in one of the articles about Richard Owen. Would you please describe what has happened with him and what causes us to need to look at whether age really impacts the ability of judges to hold their positions?
Okay, well, and let me start answering the back end of your question by saying something to you that my father once said to me as a small town lawyer when I chose to pursue this as a profession against his advice. And that is that judges are people too. And just like I'm sure we all know someone who has struggled with dementia or Alzheimer's, the same thing happens to judges. Just because they're given an important position does not mean that they cease to be human.
Well, and I think that's true. And can you tell just a little bit of the story of Judge Richard Owen? Because I think it gives an example, and then I'll go into some others as well, because I think they're so important.
Yes, Judge Owen, and this is, and you know, one of the articles you touched upon, the article in Slate, that was written, I want to say 14, 15 years ago. So this is
Right.
not something that is new. And by something, I mean the aging federal judiciary in the United States. And with Judge Owen, he was a highly respected judge in the federal courts in the Southern District of New York. And just to make it simple, New York City. And what began happening as Judge Owen got up in years is there were what I would characterize as these little lapses that are recounted in that article in Slate, but also that really became matters of public discussion 15 to 20 years ago, where a month after trying an important securities fraud case that hinged on a single email that had been sent, Judge Owen asked one of his clerks what email was. There was another circumstance where on a crime, the metaphor that the U.S. attorney used about one of the defendants was that he was the key to this operation. And Judge Owen took the word key literally.
Right. Right.
Those are some specific examples that are recounted in the article, but there are others that had stacked up. And basically, what it came down to is Judge Owen, as happens with people when they reach their late 70s and early 80s, his mental acuity, despite his brilliance in his younger and middle years, he had reached the point subjectively where he was declining. The problem is with federal judges, they have a lifetime appointment. The
Right.
Constitution doesn't say that they serve for a lifetime. It says they shall hold their office during good behavior. But articles written back then about the Constitution and the meaning of that
Right.
phrase, in particular, one written by Alexander Hamilton, mentioned that the whole idea behind this was that judges would have a lifetime appointment. And what has happened, of course, as medical science has advanced, it used to be that this was less of an issue because with many people, our bodies gave out before our minds did. But as medical science has advanced, you have, as you pointed out, an increasing age in the judiciary. And there was a ProPublica report done 15 years ago. And in
Right.
that report, they pointed out that 12% of the nation's 1,200 federal judges sitting on the bench at the district level and at the Court of Appeals level were 80 years of age or older. So, of 1,200 judges, 12%, we're talking about roughly 140 to 150 over the age of 80 or 80 or older. As you pointed out, there was one from Kansas back at that time that was over 100. And there have been other
Right.
examples like Judge Owen. There was a judge, I want to say, with the DC Circuit Court of Appeals that handles all of the patent cases where she was removed from panels hearing cases, and it was a similar circumstance. She did not want to retire or remove herself from the bench, but there were concerns by other judges, expressed by other judges and people that argued in front of her about whether or not that particular judge's mental acuity was declining. And
Well, and I think, yeah, let me interrupt you here just for a moment and ask you to do something. I
sure,
think something that certainly I was not as aware at until I had read your articles and talked with you about it. But I think the problem is people, I know you've got your light. It's okay. Uh, People do not understand that they do have a lifetime tenure. There's a
yes,
good reason for them having it. We can go to in just a moment. But what I'd like to say is, what are the issues with them having a lifetime tenure? Because what I see is there's no policy or procedure clearly about how to remove someone that cannot function. So I'd love for you to talk about what are the problems with it and what happens. And you can tell any of the stories you want or anything, because I thought there were some fascinating stories about what is happening because we just don't have a clear policy.
yes. And the whole idea behind the lifetime tenure was that because the judiciary branch, as drawn up in the Constitution, did not have uh, the army behind it, there was no really military or enforcement mechanism. The idea was there's not a risk of giving them a lifetime appointment like you might have with an executive, someone like the president. And the benefit of giving a judge a lifetime appointment was that they were not subject to political pressure, that they were going to make decisions on the way that the law should operate, not based upon popular opinion. The problem with that is when judges begin to have issues with their health, um, but don't leave the bench, that becomes an issue. And the problem is with this constitutional basis for the lifetime appointment, unfortunately, there's no statute, there is no law in place to regulate the mental acuity of our federal judges. Again, this is at the federal level, the US government level. Um, there, so there's no way of requiring that the judges undergo regular or periodic mental examinations focused on measuring their ability to process information, their mental sharpness. And there are examples of judges that when they were on the bench or when they had a position as a chief or administrative judge in an area undertaking to do that type of thing, to force judges to undergo mental examinations to determine whether or not they should still be on the bench. The example given is Judge Easterbrook out of the Seventh
Right.
Circuit in Chicago, that he was very diligent about that. There are examples of older judges that will voluntarily do it because they're concerned about the effect on the judiciary as a whole if they begin to slip. And that's great, but the problem is these are voluntary measures, voluntary steps being taken by individual judges. The sad story in that Slate article, or I consider it rather sad, is a shining star on the Federal Circuit Court of Appeals, Karen Williams, that realized in her 50s that she was dealing with
I know.
early onset Alzheimer's, and she voluntarily made a decision or made the decision to retire because of her concern about how it might affect the court and how the court she was sitting on was perceived. But the problem we have is that without some regulation, some standard, some requirement in
Right.
place, you're ultimately left with this hodgepodge or patchwork system. I can tell you that in Houston, where I've tried cases to the federal bench, one of the best judges I ever had the opportunity to try a case in front of, Ewing Werline, was in his 80s, and he was phenomenal. But there is another judge I will not mention where I tried a case in front of that judge, and I could say it was probably the worst experience I have ever had. And there were concerns that I had about whether or not that judge, I apologize for the metaphor, was losing his softball. And the
Yeah.
thing I heard through the grapevine after the fact was that a decision was being made and cases were being pulled from the second judge I'm mentioning. But again, this was a subjective decision that was being made internally at the district court level, really to try to, I would say, avoid embarrassment, because if you had some public vetting or some public disclosure or some public means of determining that, yes, this judge had a mental problem, yes, this judge was suffering from an advanced grade of Alzheimer's or dementia, then the problem is you have multiple cases where plea deals or trials might have happened in front of the judge that are going to be subject to challenge. And I hate to say it, but again, I'll go back to it. Judges are people too. And I think sometimes the decisions that are made with respect to judges that start to lose their fastball is a lot of these decisions get made behind closed doors to really try and protect the appearance of the judicial branch more so than the reality of whether or not justice is being done in every circumstance.
Yeah, and I think that's you've really put together a number of statements that show me what my concern is about. And I think the judiciary right now is probably the strongest branch we have because things are functioning. Now we'll see what the Supreme Court does. But you know, one of the things, Richard, that really shocked me is how common these lapses are. Now, I'm not presuming that any judge is not a human being because I have worked in mediation for years and I have a lot of friends that are judges or that are lawyers that try cases and things like that. But I think one of the things about your article that I thought was so powerful was to look at the question they had in it, and I'd like to share that briefly with our listeners. How common are such lapses? One answer comes from an experiment by the Ninth Circuit in 2001. The appeals court set up a confidential helpline for judges, expecting most calls to be about depression or addiction. Instead, the overwhelming majority have come from judges concerned that elderly colleagues were showing signs of slipping. The consultant of this said he received calls about 6 to 8 judges within the circuit whose mental acuity or change in temperament or other changes in behavior were troubling. So, you know, we have something here that, and I believe something. Any of the lawyers or judges I've worked with mediation in family court and so forth, I believe they want to do the best job they can. But I also know that trying to protect has led to some things that they are doing now to try to do something about it. So, what I'd love for you to do is talk about the ways that they shift cases so that my listeners can understand how some judges are really trying to protect the people that come before them. So, could you describe some of the things that happen to change how much a judge is going to participate?
Yeah, well, and I guess the benefit of a lifetime appointment is if you live to be 100, you can serve as a judge until you're 100. And if you feel like you would be bored sitting at home watching TV all day, or out in the garden tending to your roses and your petunias, then that perhaps it is a subjective decision of the judge doing this so that they don't become board. Now, with regards to the reallocating or shifting of cases, it's something the federal courts have had for a long time, that when a judge reaches a certain age, you can take what's called senior status. And you don't officially retire. But what happens is when you take senior status, you can choose to receive no cases, or you could take on a full docket. And, quite often when we're talking about some of the older jurists, because, with the one example aside, the issues with, slowing down or not grasping a lot of complex or new concepts is going to be more pronounced or more common as we get older. Um, what 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 happens is when judges take senior status, they can choose to take fewer cases on their own, or with regards to the administration of a particular district, say the Southern District of Texas, where you and I live, um, administratively, the decision can be made to give a lesser workload to some of the judges that have taken senior status. And the benefit of having those judges on senior status that will still listen to and hear cases is if you have a large influx of cases, justice works better when the judges' dockets, meaning the number of cases they're dealing with, are at a right size, meaning they have work to
Right,
keep them busy, but they don't have so many cases that you're waiting 4 to 5 years to go to trial. And
right.
the benefit of having judges on senior status is just that. If you've got a judge that's willing to take more cases and wants to take more cases, then the district can allocate cases to that judge on senior status to try to keep the dockets of the current judges, the younger judges that are still full time and are not senior status, with a more manageable docket. And
Right.
again, it's something that can be done. It is an option that is available if a judge gets concerned about one of his or her colleagues, where you simply stop sending new cases. It's not that you pull cases, but that you no longer send new cases to that judge. So they've still
Right.
got some work to keep them busy, but hopefully it's not so overwhelming as to increase the chance of the mental lapses, or by working at a more manageable level, perhaps there are less triggers or circumstances where something is likely to happen.
Well, and I think one of the things that I read about and I thought it was helpful is they can decide that a judge can review cases and make decisions, but they don't have any presentation before them. There are some cases that are primarily decided on by the dockets themselves with no presentation. And so that was one of the other things that I noted was a possibility for a senior judge. They could also do that. Um, Now, I don't know what happens if they don't have mental acuity, because that's gonna be the big issue. My question to you, I'd like for you to go more in, because I think we've covered some of these things. And by the way, I want to say something. Many, many years ago, when I was in school, I had a job with the Supreme Court, the criminal court, the criminal part of Texas Supreme Court. I don't know what the name is. I can't
The
remember it right
Texas
now.
Court of
So
Criminal Appeals.
thank you, the Texas Court of Criminal Appeals. And we had a judge, which I'm not going to give a name, but had a severe addiction to alcohol. And I happened to work for him. And there were some real concerns I had because there was a case coming up that I knew needed a really full court to make a decision about this individual because it was about a specific person. I remember the case very well because we had guards, in the capital area and all kinds of things because of all the conflict that was going on about this case. And he came in and we all knew that he was drunk as could be. And he went on the bench. They didn't say much, thank God, but he's one of them that had to make a decision about what was going to happen to this individual. And so I, and the clerk and I was his administrative associate. So the clerk and I were horrified. And so we started talking to the other judges and we said, this is what's happening. You have to understand this. And we're asking you to look at something. And amazingly enough, there were decisions made in that case by the judges themselves. But I saw times that the clerk was making a decision about a case that was one that was not going to be presented before the court, that made the decision and wrote the decision because he was incapable of doing it.
Yeah,
So
and
that is a perfect example.
well, and that's in particular, with at the district court level, there are trials. You have the presentation and the hearing of evidence and a decision being made either by the jury, or quite often, if the case is being tried to the judge, there are some issues that must be tried to the judge. They're the fact finder. No, the Court of
Right.
Criminal Appeals, the one about which you were speaking, it is not a trial court. It is what is called an appellate court. So within the courts of appeal, the only thing that they hear, they don't retry the cases here in the United States. A record is given to them, everything is on the page, it is in writing, and then they make decisions based upon the law. Does the law permit this decision? It's not a
Right.
circumstance where their object their objective is to relitigate. And in relation to what you're talking about, there are certain, I know with the Fifth Circuit, there was one particular judge, I forget who it is, that's based here in Houston, and the Fifth Circuit, the oral arguments are in at the Wisdom Courthouse in New Orleans, but certain Fifth Circuit oral arguments are held here in Houston because this is a judge that still has SNAP. The concerns, though, with the judge's age have to do with travel to hear oral arguments in another courtroom. Similarly, you'll have some circumstances where the judge will be a member of a three-judge panel and they provide their input and they provide their vote, but quite often they're not writing the opinion. They might be providing some insight or offering some editorial advice to the ultimate opinion being written by one of the other two judges on that three-judge panel, but they're not doing the lion's share of the opinion writing, the authoring of those opinions.
Right. And I want to be sure and say that I think there is a clear distinction between state judges and then and we're going to how a lot of them are elected. But there's also a difference in federal judges, and we're talking more about them in this article I'll give you and so forth. But I think even on the appellate level, we have individuals that are not able to function, and we still don't have guardrails or, as you describe, ways to clearly state what is needed when a judge becomes unable to do that. There's another side of this, though, that I'd like to talk about. I
Yes,
think there are judges you've mentioned that have tremendous wisdom. They would have wisdom far beyond what other people have had. They understands the principles, and they may not be quite as quick, but they have the mental ability to really be a resource to the court that they're serving on. So I'd like for us to talk about the purpose for federal judges having lifetime tenure is, and let's look at and see what are the reasons that we would want to have some of these stay on, because I want to be sure we cover every aspect of this.
sure. Well, I mean, you know, being a judge, again, they're people too. And like any other judge or like any other job, the more experience you have, arguably, the better you get.
Right.
So there is the benefit of that. Now, you know, there were arguments going on in the late 18th century when the Constitution was being written after the Articles of Confederation had failed concerning, do we really want to give the federal judges lifetime appointments? And again, going back to Alexander Hamilton, he argued in favor of it, but in response to concerns that were expressed even then, over 200 years ago, about judges aging on the bench and reaching a point where they would be unable to do their jobs, Hamilton's response was, that's not really a concern. Of course, back then, the average age was, the average age of the American male was somewhere in the 40s, not somewhere in the late
Right.
70s. Now, the benefit of, being an older judge, and again, who doesn't have the impediments, who doesn't have these issues, is you bring that that bench, the training you have over the years to a circumstance. The other thing you have is, again, you may have multiple judges on a floor, and if you've got a judge down the hall that has dealt with a particular issue before, you know, they are a resource to, help with questions like this, to maybe point the judge in the direction of a particular issue or case that was decided by them years ago.
Yeah, and I think that, and I wanted to be sure we covered that because there is something, I'm not going to say my age here, but there are things I'm doing now that I've done better than I ever have in a lifetime. I mean, I'm at the age that when I do my work, it is so different from anything I could possibly done in the past because I've had so many experiences.
Yeah,
I think the thing that I come to is I wish there was a way not to talk about age, but talk about mental acuity, and then ask that there be some kind of requirement to have a physical exam, and not only that, a neurological exam, so that we could then determine if there are difficulties and how can we treat those individuals with respect. And how do we help them to understand how they can contribute, but at some point they may not be able to continue. So that would be my real desire. Now, we have another topic that I think is so important, and that is about election of judges. And I know the Missouri plan is not one that I completely in favor of. I think it's failed several times. But you gave me some articles on it, and also I think it's time that we move and you describe generally how judges are being, how state judges are being chosen. And not only that, specifically Texas, because you and I both live in Texas, so we can talk about this because there's a lot of questioning that's going on right now. I think the questioning is because there's so many Democratic voters in this state that Republicans are concerned, and so they want to change something. But talk to me about the election of judges, and you can do it in Texas and then the Missouri plan, and we'll go more in detail into that.
sure. And, I won't say there are as many ways as there are states, but there is certainly more than one way of going about electing judges. And here in Texas, where we are, the elections are characterized as partisan election of judges. And what I mean by that, at least here in Texas, we're one of, at this time, only 8 states that still hold the partisan election of our judges. It's Texas, New Mexico, Louisiana, Alabama, North Carolina, and then Pennsylvania, Ohio, and Illinois. And by partisan election, here in Texas at least, you have primaries where a candidate is selected by the Republican Party and the Democratic Party, and then those candidates, the ones that win the primaries, go on the ballot. And when they're listed on the ballot, there's a designation of them as the Republican candidate and the Democratic candidate. And occasionally we will have libertarian candidates as well. But by partisan election, that's what I mean. And the one
Mhm.
wrinkle we have in Texas is I don't believe at the judicial level you can straight ticket vote anymore. That if you just select to vote for all of the Democrats or all of the Republicans, that runs all the way down to the district court level with the selection of judges. But still, I could go to whatever ballot page the judge is listed on, and I'm going to know by simply reading next to the judges whether they are a Democrat or a Republican,
Right.
because that will be listed on the ballot. So that's what I mean by partisan elections. And in Texas, the party candidates are selected by a primary election. But in other states, it can be different. Louisiana, the party affiliation is listed on the ballot, but Louisiana has what's called a jungle primary. So the two people that make a runoff could very well both be Democrats or both be Republicans. Um, I want to say in Pennsylvania, you actually have the parties that will select the judicial candidates, and then the candidates that are selected by the parties then go on the ballot and are voted on with their party designation on the ballot. But that's what we mean by partisan elections, is focusing on the ballot that you're going to see in November during the general election. You can know what party a judge belongs to by simply reading the letter next to their name. Is it a D or is it an R?
Right. And I think, and since we're on the election process for judges, I think it would be good to go ahead and cover that. So there is, so I want to talk about a little bit about the nonpartisan election because it happens in 15 states. And I didn't look up all the states, but I know that it happens in 15 of them. Now, one of the reasons that they thought this would be helpful is if you don't know the parties of the individuals, judges, then you would have to study more what was happening. But my sadness is what I see is there are loads of people that don't take time to even study those individuals. And I think it's dangerous because I think we have to accept something. In Texas, if you're going to vote straight party, then you have to go ahead and stick with your party, or we're going to have some judges elected because somebody didn't mark their ballot for a specific judge. And I think there are problems with it. But nonpartisan, you're supposed to study more. Now, I know something. In Texas, we have the opportunity for the League of Women Voters. We have all kinds of presentations of things about who they're encouraging us to vote for based on parties or whatever else. I don't understand how they think that nonpartisan elections are going to improve because I know something. Every state is going to put out whose person the party is. So, what's the reason they would choose nonpartisan elections?
Uh, the the simple idea behind nonpartisan elections is, as you mentioned, if we don't know someone's party affiliation, we're going to vote on the judges based upon their merits, not their party affiliation. The the breakdown of this simple idea is that with elections and with judicial campaigning, it's pretty easy to realize who your party's candidate is. And on a statewide level, where people are paying enough attention, the fact that the election is nonpartisan really is not going to matter that much. And the example I would give to that is the recent Wisconsin Supreme Court race. If I recall the numbers correctly, over $100 million was spent fighting over one place on the Wisconsin Supreme Court. And I think that if you look at the data, I believe that Wisconsin holds nonpartisan judicial elections, but everyone across the country knew that Susan Crawford was the Democrat running for that seat on the
Right.
Wisconsin Supreme Court. And you had big money going in behind Susan Crawford. I don't mean large donations from a dollar value standpoint. Hers was more grassroots fundraising, but then you did have people like Elon Musk throwing a lot of money behind the Republican candidate running in that race. So, the idea is that by eliminating the party affiliation, you focus more on the merits. The reality is it doesn't always work that way.
Right, and I think that's true. And one of the things I was going to say is because I want us to get into Missouri, and I'm watching our time too. There's hybrid. There's when the legislature appoints, the judges in a state. I would like to go to the Missouri plan because Texas is supposed to consider the Missouri plan, and I don't think it's healthy. So I know the Missouri plan is based on merit selection and assisted selection. And I'm going to say if you're a little darker, don't worry about it.
I can't
on
get the
this.
light to stay on, so this
Yeah,
is the
no,
failing of
it's
my
okay.
office.
Yes. So what I'd like for you to do though is talk about merit selection and assisted selection, because I really feel uncomfortable Texas ever choosing this. Talk about it and then make any comments that you need to make, about the Missouri plan, because it has failed many times.
Well, and let me say this, and I should have started with this because um, I used to think that the Missouri plan would be the way to go. And as I've grown older, what I realize is there's no perfect way of selecting judges because one of the issues you run into with this Missouri plan is the idea is you have merit selection. So, in particular, focusing on urban communities like St. Louis or Kansas City, the idea behind merit selection is you have a panel of attorneys or educated people that will get
Right.
together, and quite often they will interview the candidates for the judicial office, and a determination will be made on particular candidates that are qualified. And with merit selection, the way it works is that individual under the Missouri plan would then be appointed to the bench. And the Missouri plan preserves, it's really kind of, it depends on whether you're in a rural or an urban judicial district or judicial circuit. The idea is you have this merit-based selection from a nonpartisan committee, and then after the judges spend a year in office, the public gets to vote on whether or not the judge is or is not qualified. And if the public vote is that the judge is not qualified, what then happens is the judge loses the seat and he or she will lose the seat, and it goes back up for a merit selection again. The problem with this is the concept of a nonpartisan committee to decide these issues. And there are multiple
Right.
criticisms about it. One would be that, okay, well, if we've got the public selecting three people on the committee, and we've got the local bar association selecting three people on the committee, and we've got the governor selecting three people on the committee. Is it truly nonpartisan? Do you have large law firms in cities like St. Louis and Kansas City that are largely controlling the bar association's slate of candidates? Do the three people being appointed by the governor? Are they all within the governor's political party? And ultimately, the issue becomes one where quite often the appointments are not truly based on merit, but based more so on, you know, backroom conversations about who the governor would prefer to have on this seat,
Right.
or who a particular large law firm would prefer to see on this seat. I mean, the reality is when you go to a selection of judges based upon a smaller group of educated professionals, the idea is that it will work better because you're taking the politics out of it. The reality is that it doesn't always work that way. And, you know, I'm going to go back and from a historical standpoint, I grew up in a small town. And every 4 to 6 years, probably the most important election on the ballot for us in that small town, in our small ballot that was 2 pages long, was who was up running for district court judge. It was important. So, in a smaller community where you have 5,000, 10,000 voters, people know whether the judge is good or bad. So, and I would say the same is true in rural communities in Missouri, in Texas, in California. Pick a state. Because the judge has a more important position in the rural communities, you really have, I would say, more educated decisions being made in the smaller counties in Texas. the problem you get into with voting in Harris County, at least, and I run into the same problem. In 2024, I want to say that there were 40 to 50 seats
Right.
up for election on civil district courts and criminal district courts and family district courts and county criminal county courts at law and civil county courts at law and probate courts and the you know
Right.
the problem you run into is I'm not a criminal lawyer. I'm not going to be in the criminal courthouse and I'm not going to know enough about the district court judges or the county court at law judges trying criminal cases. I'm going to have a small subset of judges, the 10 or 15 civil district court judges that are running, judges in the first or 14th courts of appeal that are running, that I can make an educated decision upon. And I will take in the educated decisions and opinions offered by colleagues of mine with respect to particular judges in the family courts and criminal courts to make my decisions. But in, the average election, if there are 40 seats up to be voted on amongst the judges in Harris County, there are maybe 10 where I don't know enough to make an educated decision. And what I do, Jackalyn, is rather than making the wrong decision, there will be 10 judicial races in any given, even year election, 24, 26, 28, that I'm probably not even going to vote on because I don't know enough to give an educated vote. And that really is, the articles I sent you, the information I sent you, I don't think there's really a focus on that. But having grown up in a small community and having practiced law for the past 30 years in Houston, I really think there's a distinction to be made for once, not based on political parties and not based on race, but honestly based upon urban and rural. There's a lot less work required to know whether or not you've got a good judge in Crockett, Texas, than there is to know whether or not you've got 40 good judges in Houston, Texas.
Well, and one of the things I want to say is that when the women's rights movement happened several years ago, a bunch of us formed a group, and so we have men and women together. And what we do is we spend a lot of time with illegal women voters. We spend a lot of time looking and asking lawyers about what they think about the various elections, and we try to do our best. But one of the things that I want to mention is in my 146, I have Heather Cox Richardson talking. And at the present time, we cannot afford to not go ahead and vote for those 10 judges, even though it may be based on party. Because what she's talking about is every Republican goes in and they're going to vote on every judge, whether they know them or not. And in the current situation we're in, we're going to have to vote on those 10. Now, I'll admit, I'm glad we have a sample ballot because then I go through all the handouts I've gotten from my group and I go through everything that I possibly can and read. And then we meet and we discuss these things so that they can help each other make good decisions. And I spend a lot of time calling my friends that are lawyers saying, what do you think about this? Who it is? And I don't just call Democrats. I call some of my Republican friends and say, what do you know about these people? And I know something that some of us that are Democrats made a decision to vote for the Republican judge in a position because we knew that our Democratic candidate was not acceptable. But I think a lot of people do not do that. And I think what we need to realize is, if nothing else, as Heather Cox Richardson says, with the current environment we have, our local elections are very, very important. So we need to go ahead and vote by party if we're Democrats, because the Republicans are going to do that. It is a pattern of theirs. So what I want to do is I want to say first, Richard, I've learned so much in just having these interviews with you, and I'm extremely grateful. And I am very thankful for the research you do and all the things. And today, I think your talent is that you have such a respectful and clear way to describe to someone like me or the listeners that I have that maybe don't know as much about election of judges and so forth, that you've done a great job to share that with us today. So I want to thank you, and I'm looking forward to what our next topic will be. Heaven knows what it'll be, but I'm certain it'll be just as stimulating as this one. So thank you very much for being here today.
Thank you.
And the other thing I'd like to say to my listeners, please remember that you're going to have references. This time I'm going to provide you some questions that maybe if you want to read the references, you can go through and see if you can answer the questions. So it'll be just a little quiz. So thank you all. And now we have ended our 147, and it's about Calais, and it's also